466. Florence, it's 466, ba? So is the claimant in court?
Yes. In court, yes, my lord.
Okay, she has joined?
Yes, sir.
Okay. It's NW or NWU, ba? Okay, we've lost yes, Mr. Akin.
Profound respect to the court. Oluwafemi Akinolu for the defendant.
Okay, Ojo, you're back.
Sorry, sir, it went off. My apologies.
Okay, you're back.
Yes, sir.
For the claimant, why Mr. Oluwafemi for the
yes, for the defendant.
Defendant. Yes, Ojo.
My lord, the matter is related to the report of settlement.
Yes.
Or in the alternative.
Yes.
Hearing of claimant's motion for summary judgment.
Yes.
Based on this scenario, my lord.
Yes.
We got information from the defense counsel that
yes.
they were coming to our office this morning, latest around 2:10, with the checks and the terms of settlement for signing. So they told us to inform our clients that they should be in our office at that close to that time.
Yes.
Yes, which we did. But unfortunately, we waited for them. The clients waited for them till 12 o'clock, my lord.
Yes.
I made series of calls to a lawyer in the defense software who told me that they were waiting for their client to send the terms of settlement. Of which I told him that the check is the crux of the whole thing. If they could easily send us the check, the terms of settlement could be dealt with later.
Yes.
Yes. So that was what I told them. But unfortunately, for reasons best known to them, they did not send it. Series of calls made letter to them. They did not reply till up to this moment, Lord.
Okay. So there was no settlement. It
no,
didn't
my lord.
Out. Okay.
No, my lord, it didn't work out.
Okay. So you intend to take your application for some?
Yes, my lord. Yes, my lord, exactly.
Yes, Mr. Oluwafemi.
My lord, I confirm the communication as explained by the claimant counsel. Yes. However, it was I couldn't make it to the office because, like the counsel has said, I was waiting for the defendant to present the terms of settlement.
Yes.
Although initially, as I've told them, they sent in a check to the office.
Who sent
that? The defendant. The defendant had actually issued the checks.
Did you forward the check to the claimant's lawyers?
No, I could not.
Okay.
Yes. And that was because my colleague who was in court the last time mistakenly or erroneously informed us that the matter was adjourned to 16th. That was Monday. Until when the claimant counsel called yesterday to inform me that the matter was coming up today. And according to what we planned, I was of the mind that the defendant can still forward the terms of settlement to us because we drafted the terms of settlement, we forwarded to the claimant and also to the defendant. Initially, we were looking at the fact that if the claimant can sign, then they will bring it to us. We give them the check. But until...
Uju, did they forward the draft terms to you?
Yes, my lord, they did forward a draft terms to us, but there was some
things
in it exactly that was not okay with us. So we amended it immediately and forwarded it back to them.
Okay. Yes, and Femi, yes.
So it was this morning, when I saw that I couldn't make it to that time because we agreed to, that was when I forwarded the copy, the checks. I forwarded it to the claimant counsel that in the benefit of doubt, not to appear as if maybe we are stealing or anything. We have the check with us. That was
when did you forward the checks to them?
That was this morning. Not the
this
check.
morning.
A scanned copy of the checks with us to at least buttress the fact that we intend to settle this matter. We have the check, but it will be fruitless for me to just come with the check when I don't even have the terms with me. It is best that I also come with the terms. We settle the whole thing once and for all. Then we proceed to filing and adopting. But unfortunately, it could not materialize, especially when the claimant counsel, some days ago has even filed and served us a copy of a new copy of their motion for summary judgment, which caught me by, that was on Tuesday.
On Tuesday?
On Tuesday, yes. Which caught me by surprise that why would you proceed to filing another motion for summary judgment when we are confident that we will resolve this matter and we want to close this matter once and for all?
Oju, did you file another motion for summary judgment?
Yes, sir. We did.
When?
After we filed it on 10th of May, my lord.
Okay, this was on Tuesday.
Yes, my lord. My lord, this was as a result of the fact that we had waited for them to reply. As a matter of fact, our last communication with them via mail was 21st of April. We waited for them from that period to up to the time before we filed that motion because they were not ready to reply us. They were not ready to say anything anymore.
The motion is not even in the, you file a motion, another motion for summary judgment.
Yes, actually, it's an amended one. You know, on the last adjourned date, they've already paid the clients some money.
Okay.
So we couldn't still move on with that amount. So we had to amend it based on the amount that they are now owing them now.
Okay.
Yes, my lord. Yes, my lord.
And was the defendant served?
Yes, my lord, the defendant was served.
Yes, my lord, we got the process on Wednesday.
Okay, that's 2 days ago.
2 days ago, my lord, yes.
Then, Uju, if that's the case, it means you now have two motions.
My lord, actually, our plan was to withdraw the former one.
The earlier one. Okay,
yes, my lord. Yes, my lord.
If you are going to withdraw the earlier one,
okay,
and go ahead with the
The
extant one,
Okay.
it means the defendant still has to have time to react to
reply.
the present motion you filed. Then because you filed it on the 10th of May.
Yes, my
Tuesday.
lord.
That also?
Yes, my lord. Yes, my lord.
And you filed the motion in all the sister cases?
Yes,
Uju, can you hear me? Uju? Yes, Uju?
I think maybe our network is on.
Yes. So, Femi, I said the motion was also filed in the other cases.
Yes, it was. The 7 matters, all 7 matters.
Okay. Yes, we've lost Uju, but let her come back so that we
continue.
Let her reconnect so that we'll
Hello. Sir, if they are still ready to settle, you can give them 27th of June. And then once you got the earlier ones, and this one will be done 27th June. So it will now be for what was done for today. So it should be for example of settlement or promotion of judgment. Since they said their check is ready, what do they want? Is not money and check. Let them put their check and just finance. Motion for judgment. Next slide. I want what so 2 Fridays is better than next Friday.
Yes, Uju, and you are back. Hello, Uju. Hello, Uju, can you hear us?
Hello, my lord. I'm so sorry.
Maybe you should call the woman to mute.
It's okay. We can hear you. Yes.
I'm so sorry. We are having light problems here. Forgive me. Sorry.
It's okay. We can now hear you.
Okay. Right, sir. So
you have not filed another motion on Tuesday.
Yes, my lord.
And the motion is also in the other cases.
Yes, my lord. It's on one of them.
It means the defendant has 7 days to react to the motion. The defendant is still within time to react to the motion.
As the court pleases.
Yes. So, Uju, what do you do now? Since there is another motion filed, or someone which was served on the defendant on Wednesday, it means, and the defendant has 7 days within which to react to the motion. It means the defendant is still within time to reply to the motion. So, what do you do?
I don't know if my lord could maybe apply just with a short date.
Okay, we adjourn for 2 weeks to enable you parties either report for settlement or
proceed with the hearing of the
come and take the motion for. Yes, Femi.
Yes, my lord. In all sincerity.
Yes.
Like I mentioned earlier.
Yes.
We want to settle with them.
Yes, we can still settle.
So, but apparently, perhaps the hostility between the parties is causing the whole distrust.
But Mr. Femi, you've already had the text, right? You already had yes. What now remains is the
Yes, that's where I'm going, my lord.
And
the defendant is saying before we give them the check, they have to sign. And that was what brought up
the defendant or the claimant.
Yes, the claimant. Because my lord, we've had.
It's saying what?
The defendant is saying that before we hand over the check to them,
yes,
that there must be a clear path to settlement.
Yes.
And my lord, this is because I personally fell victim to that with the claimant. Initially, we had the initial agreement between the parties was to settle within a space of 6 months. And if my lord would recollect that about 2 or 3 sittings before the last, right there in the court, we issued a check to the claimant counsel.
Okay.
Having collected the check, my lord, the claimant counsel stood up in court and started saying, okay, they've paid off part payments, but they are not willing to proceed to settlement because parties have not discussed the issue of interest.
No.
So
Yes.
that cynical nature was what caused my client, the defendant, to insist that until and unless there is a clear path to settlement, that we must not hand over that check to them, which in all fairness, I understood. But I told the defendant that, look, the only clear path to settlement is this. One, either you sign the terms of settlement and then you give it to me, and I go with the check. Any of the party who is around will sign, and then they get their check, and everybody move on. But we present those checks. My lord, I'm sorry. Or we present those checks to the court, and then when parties have executed the terms, adopted the terms, then they can come to the court and collect the check from the court.
But Mr. Femi,
it would be unfair even to
Mr.
me
Femi,
as a lawyer.
Mr. Femi, can you hear me?
My lord, I'm with you, sir.
The fact that you have given the claimants.
I'm with you, my lord. I'm here. I can hear you, my lord.
And the fact that you have given them the checks doesn't mean that you people are not going to settle. You can give them the check, still give them the check, collect the check, and even if you don't agree on the terms, it's for them to come and prove their case. They may not be able to prove all what they have claim for. You can still give them the check and get interest in the settlement. It's for them to come and if they still insist on the issue of interest, it's for them to come and prove that fact.
My lord, please, sorry, if I may come in, my lord. If I may come in, my lord.
Yes.
My lord, please, I would like to come in. Actually, my lord, my clients waived the issue of interest so as not to prolong this whole issue. Contrary to what he said about 6 months, the 6 months came after they had paid the first money, and now we are talking about the remaining balance. The remaining balance is what we are talking about, that they have to pay within 6 months.
Not the interest.
Not the interest. We are no longer talking about they waived the interest because of that 6 months, because my clients were clamoring for 3 months. But they proposed that they could pay within 6 months. My client said, in the interest of fairness and everything, let's waive the interest so that they can pay up the amount for the 6 months so that they can go with the money. So the issue of interest that he's bringing up now, I don't understand.
I wouldn't know when Barrister Duke came into the matter, but the principal partner, Mr. Omishore and Mr. Emmanuel, were aware of this position. And I handed over that check personally. My lord, I'm speaking from the bar. I wouldn't say what, and it reflected on the record of the court when Mr. Esen acknowledged the receipt. And then he proceeded to say it reflected in the record of the court. I wouldn't be saying what is not realistic or saying things that are not.
Before me,
Barrister Duke came into the matter. But
before me,
as far as I'm concerned,
Femi, is it before me or before another judge?
My lord, before my lord. Sometimes that will be sometimes in November or December. I can't lay.
That should be around November.
I would have specifically pointed it out.
Yes. That should be around November.
Because
Okay, on the 21st of October last year, Mr. Essien appeared, then Mr. Akin appeared for the defendant.
Yes, for the defendant.
Matter as for hearing of application for summary judgment, but there is a new development because parties have agreed to settle the matter. And in circumstance, we asked for the 30th of November 2021 for report. Then Olufemi, the position cases adjourned to the 30th of November 2021 for adoption of terms of settlement. The proceedings in this suit shall apply to the other suits. On the 30th of November, Essien appeared, Olufemi appeared. The matter is for report of settlement, and the defendant has paid some checks to us, but there are still some gray areas to address. In the circumstance, we asked for another date for report of settlement. Then the matter was adjourned to the...
Lord,
the 8th of February, my lord.
That gray area mentioned by Mr. Essien was the issue of interest.
Then on the 8th of February, Mr. Essien said, the matter is for report of settlement, and we are still looking at some gray areas. In the circumstance, we asked for a date for adoption of the terms of settlement. Mr. Oluwatoye, that's the position. Matter was adjourned to the 24th of March 2022 for report of settlement. Then on the 24th of March, Uju was in court.
Okay.
Oluwatayo was also in court. The matter is, but settlement failed.
That's my colleague.
In the circumstance, we wish to proceed with our pending motion for summary judgment. Oluwatayo, we have sent some checks to the claimant, and we are trying to settle the outstanding sums. So court said case is adjourned to the 13th of May 2022 via Zoom for report of settlement and or hearing of the claimant's motion for summary judgment. So that is the...
Exactly.
Yes.
So, my lord, all I'm saying is that... Hold on.
That confirmed what I said earlier.
Yes, Uju.
Okay, my lord, all I'm trying to say is that we are no longer talking of the issue of interest. They waived that interest because of that 6 months.
You're talking of the outstanding sums.
No matter whatever the case.
Okay, whatever is going to be, we can still adjourn for report and hearing of your motion for summary judgment.
Oh, yes, we've agreed on that. I only mentioned the issue of interest.
Issue of what?
But
either
hearing of their motion or
Mr. Femi. Mr. Femi.
My lord, there's no problem. I can say before my lord, I can say before my lord that my lord.
Yes, I can hear you. We are going to adjourn for...
I can hear my lord clearly.
Oh my God.
So Mr. Femi.
Hello, my lord. Can you hear me? My lord,
yes, I can hear you.
Okay. My lord, like I said before, I don't know why the Defense Counsel is bringing up the issue of interest now. Like I said, we have already dealt with that. As a matter of fact, all the terms of settlement that they brought to us, my lord, there was never an issue of interest there. They did not even include anything that has to do with interest there. And that was even the sole reason.
My lord, Mrs. Udu, that was before you came in. I only
my
said
brother, irrespective of
before you came in.
Good, before I came in, but that has been a while. The terms of settlement that was sent to us has nothing to do with interest. All the terms of settlement you're bringing has nothing to do with interest. So I don't understand why you're raising that issue now. You should not ever have raised the issue. That is what I'm talking
not
about.
The issue. I'm only buttressing the fact that an issue, well, whatever the case, I'm of the humble opinion, my lord, that as soon as the defendant send us the executed terms of settlement from their part,
my lord,
I will
yes.
reach out to
no, allow him to land, yes.
Okay.
And fix a time when all the parties will be either in the office or anywhere. Have a problem with that. So,
Mr. Femi,
as soon as we have the executed copy, I just
Mr. Femi, can you hear me?
As the court pleases, Femi, could you please allow the court to talk?
Can you hear me? Yes, Mr. Femi.
My lord, I'm with the court.
Yes, the draft sent to you by the Claimants Council.
Yes.
Draft of the term, did it include the interest?
No, it doesn't. We've resolved the issue of interest.
So why are you trying to bring in the issue of interest?
Oh, I don't understand.
So I wasn't okay.
Sorry, please. We are going to adjourn to 27th of May.
Okay.
That's on Friday.
Okay, my lord. Okay, my lord.
27th of May on Friday. We are going to send the link, the Zoom link to you. 27th of May.
27th. Okay.
Yes.
Okay.
For report of settlement or hearing of the motion
proceeding
for
to hearing the motion for.
Yes.
As the court pleases.
As the court pleases. My lord, sorry, okay, sorry.
Yes, I can hear you, yes.
My lord, the issue that Femi is bringing up about bringing the terms of settlement with the checks. Some of our clients are outside Lagos. As a matter of fact, like I said, my lord, the time frame that was even given to us within yesterday and today was so short. But some of them were able to make it, but those that were outside Lagos could not make it. So this issue of bringing in check and bringing the terms of settlement at the same day, it's going to be a big problem for us. That was why I insisted that if you could send it. Femi, allow me to talk, please.
Please allow her to. Yes.
That was why if he can bring the checks to us, we can, and the terms of settlement to us, we can sign and hold on to the terms of, and then wait for our clients that are outside Lagos. Inform them, okay, within so and so period, we want to file this thing, give them time to come down to Lagos and come and sign. Then when they are done, we can take it to them, which will even be easier for him instead of shuttling between from the office to here. Because if he had come today, those outside Lagos are not here. There were some that we are here, but those outside Lagos are not here.
I even thought that once the terms are agreed upon,
okay,
the lawyer for the defendant doesn't have to do anything with the claimant. It's only to send the copies to the Claimants Council for him to, to call his counselor and sign. You don't need to see.
Thank you.
Yes.
Thank you.
Do you need to meet the? Do you need to meet the defend? I mean the claimants.
As the court pleases.
Thank you. As the court pleases.
Once the terms are agreed upon, you just
thank you.
Forward copies to the lawyers for the claimant. It is them that will take the responsibility of calling their client to converge and maybe have
you,
a
my
meeting.
Lord. Thank you.
So that once you have drafted the terms, they are agreed upon. Just sign your part. Just sign your part and send the remaining to it is for them to, wherever they are. It's for the lawyer to get them and have the terms signed. Instead of saying that you want to, I don't think.
As the court pleases.
You should try to make the job easier, please.
As the court pleases. As the court pleases.
So it's now agreed that we are adjourned for report and or hearing of the motion via Zoom. Is that agreed?
Yes, my Lord. It's
motion. Yes, as the court pleases.
As the court pleases.
It's agreed, my Lord. 27th is on. 27th is convenient.
It's convenient.
Okay. So cases adjourned to 27th of May 2022 for report of settlement and or hearing of the claimant's motion for summary judgment via Zoom. The proceedings in this suit shall apply in suit number NICN stroke LA stroke 467 468 470 471 473 and 498 2019 respectively.
As the court pleases. Thank you, my Lord.
Thank you. So, gentlemen, that's all for today.
As the court pleases.
And I wish you a very good evening.
Same to you, my Lord. Thank you very much.
So, see you next time. Till then.
All right, my Lord.
Bye-bye.
Bye, my Lord. As the court pleases.